In our webinar that we had a couple of weeks ago, I mentioned to everybody that we were unfortunately unable to make the stars align to have Marsha from the US join us, but she's very kindly agreed to offer some short remarks so that we can put that together with the recording. So thank you very much, Marsha, for making a little bit of time for us so that we can hear that important perspective. So to introduce Marsha, she's the Chief Legal Officer of Juvenile Law Center in the United States, who've been central to a lot of the reform that's happened, particularly in the area of sentencing. And so, Marsha, it's great to get your perspective on the US, because as we discussed in our webinar, the US experience, particularly in relation to brain development, we've really seen that have a halo effect in terms of influencing case law and policy in a range of other jurisdictions. So can I ask you to talk about your experience of reform of sentencing of young people for serious offences in the US, and how has reform been advanced?
I would say that the reforms have been both dramatic and disappointing. And I say that because there's no question but that in a series of United States Supreme Court decisions that came down beginning in 2005 through 2020, significantly and quite dramatically transformed youth sentencing, particularly for young people who are tried as adults in the United States, which happens all too often, and end up being sentenced in accordance with adult criminal justice sentencing policies and practices. And those decisions relying exclusively and quite extensively on adolescent development, brain development, social science research, did strike extreme sentencing. We got rid of the death penalty finally for young people in 2005 and got rid of life without parole for young people charged with non-homicide offenses. Still allow it for youth who are convicted of homicide, but hopefully in rare and exceptional circumstances only. And I think that that was enormous progress for a country that is highly punitive, highly retributive in how it thinks about its justice system, how it defines justice, and that is also addicted to incarceration. So to get rid of that extreme level of sentencing for young people, yes, dramatic, amazing, important. We're grateful. But the story is not all a happy one, because I think that, again, our addiction to incarceration really has meant that while we no longer formally sentence very many young people to formal life without parole sentences, we sentence them to decades in prison. And for a young person, especially convicted of homicide, to receive a 40, 50, 60, 70, 80-year sentence, that's not uncommon in the United States. And those sentences are largely the equivalent of life without parole. As you go up in the number of decades, those kids are going to die in prison. And even if they come home after 40 or 50 years, that's not a lot of life left for them to have the opportunity to come back into their communities, be reintegrated with their families, with friends, create new experiences, create new families. So I think that for me, it will always be a mixed bag. Grateful for the reforms that we have achieved, disappointed that we have not done more.
Thank you. And that's a really good point about, often we, I suppose, rightly celebrate, a non-indeterminate sentence, that there will be a chance of parole. But as you say, that's really striking to think about that length of time, and the fact, as you say, that that is effectively for a lot of people the indeterminate sentence. But I suppose one of the things we've seen after major sentencing decisions in other jurisdictions is that the resentencing and the parole processes that I understand happened in the US as well. And so one of the things we were talking about was, I suppose, the reality of those parole applications for young people when they don't actually have a lot of time to show before the sentence, whereas for an adult offender, often they could point to family or work. Has that been the case in the US, that there may be difficulties with parole applications because simply the young person doesn't have anything to show the parole process?
So that's an absolutely brilliant question, actually,
Mm,
for a couple of reasons. Number one, yes, that's absolutely correct. Traditionally, the way that parole operates in the United States for any average person who has been incarcerated and comes before a parole board, the parole board will look to their community ties, family ties, traditional indicators of stability back in their communities. And kids don't have that.
mm,
If a child goes into prison at 15, 16, 17 years old, they have no family and they have no work experience. And
mm,
they may have limited educational opportunities while they're in prison. So that absolutely can work against them. There's been an effort, of course, as a consequence of the sentencing decisions to try to think about parole eligibility differently for young people. But what I would say is, again, it's a mixed bag. There's good news, bad news. The good news is, yes, that there is an acknowledgement, I think, in some jurisdictions, among some parole board members, that you have to assess a child's eligibility to come home differently. Often really drawing more on what their experience was in prison than what they brought into the prison setting before they got there. But the other thing that's happening, again, the disappointing side of this is that there are many states across the country where young people face enormous hurdles to get parole. The parole process varies from state to state. It is not uniform. We have 50 different parole systems. Parole in the United States is considered a privilege, not a right. Even when you are eligible for parole, even when you have a parolable sentence, it's a privilege for you to get out before the end of your sentence. And in some jurisdictions, it is given out very, very uh, narrowly, in very limited circumstances. We have some states across the country that are releasing almost no young people who are serving parolable life sentences. So again, it is a good news, bad news situation.
yeah, that's really interesting, and I think something that we're seeing this side of the world as well. Um, so my third and final question is just picking up on that brain development evidence theme, and certainly something we discussed at the webinar was around how I think that brain development evidence can really advance more principled and humane sentencing, but we do see instances where it's a double-edged sword, where perhaps it might be seen as making that young person more risky, that they're, as one person said, a ticking time bomb. They've got something wrong with their brain. Like, has that played out in the US context, or have there been any lessons from perhaps some of the risks if that evidence isn't portrayed in a certain way?
This is again a little bit of yes and no. I think it's mostly no, and I'll just say a little bit about where that might come up as an issue. I think that it's important for folks who are not here in the US to appreciate and sympathize with us that our path to more humane treatment of young people in the justice system is through neuroscience. We do not subscribe. Obviously, we have not ratified the UN Convention on the Rights of the Child. The notion of human rights and human dignity do not appear in our Constitution. If you talk about those concepts in court in front of a judge, they may stare at you blankly, quite honestly, because it's just not how we think about the treatment and the ways in which we hold young people responsible. That's not part of the conversation. Neuroscience, I think, saved us from what was really a rather grim fate for young people who were facing extreme sentencing in the adult criminal justice system. So, in the absence of joining the international community and subscribing to the notion of human rights and human dignity for all, not just for children, this is all we have, and so we're grateful for it. I think to the other piece of your question, it's interesting. I think that for young people, the pure notion of adolescent development, the idea that the scientific research teaches us that young people develop more slowly, mature more slowly, their ability to make smart decisions about their conduct and their behavior just comes later, is a positive, and it has really served to be mitigating evidence in virtually all circumstances. What does happen in the US is that when adult individuals are diagnosed or believed to be suffering from some type of brain injury, particularly like a traumatic brain injury that is not developmental, that is absolutely something that can be much more detrimental to a sentencing determination, that they're viewed as not fixable, and they are viewed as more dangerous.
Yeah, thank you for making that distinction, because I think it's one, now that I reflect on it, that does play out here as well. But I think it's so important when we have those experts that can really speak to how the evidence is portrayed. Well, there's been both positive and negatives to report from the US experience, but when to pick up on what you said about being grateful for the neuroscience and the advances it made, I think we are very grateful as well in other jurisdictions, because that research and that strategic litigation that has occurred in the US, we've seen that have that halo effect. Um, Even in jurisdictions where there is a very stringent human rights framework. So we have to really acknowledge our US colleagues for, both doing that work and also making those links with people internationally, because it's clear that those cases and the work is being picked up regularly. So thank you for your part in that.
Thank you.
Okay, I'm just going to turn off the recording now.